Aboriginal title is a common law doctrine that the land rights of indigenous peoples to customary tenure persist after the assumption of sovereignty. Under settler colonialism, the requirements of proof for the recognition of Aboriginal title, the content of Aboriginal title, the methods of extinguishing Aboriginal title, and the availability of compensation in the case of extinguishment vary significantly by jurisdiction. Nearly all jurisdictions are in agreement that Aboriginal title is inalienable, except to the national government, and that it may be held either individually or collectively. Aboriginal title was first acknowledged in the early 19th century in decisions in which indigenous peoples were not a party. Significant Aboriginal title litigation resulting in victories for indigenous peoples did not arise until recent decades. The majority of court cases have been litigated in Australia, Canada, Malaysia, New Zealand, and the United States. Aboriginal title is an important area of comparative law, with many cases being cited as persuasive authority across jurisdictions. Many commentators believe that the doctrine is applicable in all common law legal systems. Aboriginal title is also referred to as indigenous title, native title, original Indian title, and customary title. Aboriginal title jurisprudence is related to indigenous rights, influencing and influenced by non-land issues, such as whether the government owes a fiduciary duty to indigenous peoples, while the judge-made doctrine arises from customary international law. It has been codified nationally by legislation, treaties, and constitutions. English colonial legacy. Aboriginal title arose at the intersection of three common law doctrines articulated by the Judicial Committee of the Privy Council: the Active State Doctrine, Doctrine of Continuity, and the Recognition Doctrine. The Active State Doctrine held that the Crown could confiscate or extinguish real or personal property rights in the process of conquering, without scrutiny from any British court, but could not perpetrate an act of state against its own subjects. The Doctrine of Continuity presumed that the Crown did not intend to extinguish private property upon acquiring sovereignty, and thus that pre-existing interests were enforceable under British law. Its mirror was the Recognition Doctrine, which held that private property rights were presumed to be extinguished in the absence of explicit recognition. In 1608, the same year in which the doctrine of continuity emerged, Edward Coke delivered a famous dictum in Calvin's case that the laws of all non-Christians would be abrogated upon the conquest. Coke's view was not put into practice, but was rejected by Lord Mansfield in 1774. The two doctrines were reconciled, with the doctrine of continuity prevailing in nearly all situations in Oyek and Vidal. The first indigenous land rights case under the common law, Mohegan Indians v. Connecticut, was litigated from 1705 to 1773, with the Privy Council affirming without opinion the judgment of a non-judicial tribunal. Other important Privy Council decisions include in re Southern Rhodesia and Amadou Tijani v. Southern Nigeria. The former rejected a claim for Aboriginal title, noting that some tribes are so low in the scale of social organization that the usages and conceptions of rights and duties are not to be reconciled with the institutions of the legal ideas of civilized society. Such a gulf cannot be bridged. Quote, 2 years later, Amadou Tijani laid the basis for several elements of the modern Aboriginal title doctrine, upholding a customary land claim and urging the need to study of the history of the particular community and its usages in each case. Subsequently, the Privy Council issued many opinions confirming the existence of Aboriginal title, and upholding customary land claims. Many of these arose in African colonies. Modern decisions have heaped criticism upon the views expressed in Southern Rhodesia. Doctrinal overview. recognition. The requirements for establishing an Aboriginal title to the land vary across countries, but generally speaking, the Aboriginal claimant must establish occupation from a long time ago, generally before the assertion of sovereignty, and continuity to the present day. Content: Aboriginal title does not constitute allodial title, a radical title in any jurisdiction. Instead, its content is generally described as a usufruct, i.e. a right to use, although in practice this may mean anything from a right to use land for specific, enumerated purposes, or a general right to use which approximate fee simple. It is common ground among the relevant jurisdictions that Aboriginal title is inalienable, in the sense that it cannot be transferred except to the general government, although Malaysia allows Aboriginal title to be sold between indigenous peoples, unless contrary to customary law. Especially in Australia, the content of Aboriginal title varies with the degree to which claimants are able to satisfy the standard of proof for recognition. In particular, the content of Aboriginal title may be tied to the traditions and customs of the indigenous peoples, and only accommodate growth and change to a limited extent. Extinguishment: Aboriginal title can be extinguished by the general government, but again, the requirement to do this varies by country. Some require the legislature to be explicit when it does this. Others hold that extinguishment can be inferred from the government's treatment of the land. In Canada, the Crown cannot extinguish Aboriginal title without the explicit prior informed consent of the proper Aboriginal title holders. New Zealand formerly required consent, but today requires only a justification, akin to a public purpose requirement. Jurisdictions differ on whether the state is required to pay compensation upon extinguishing Aboriginal title. Theories for the payment of compensation include the right to property, as protected by constitutional or common law, and the breach of a fiduciary duty. Percentage of land. Native title in Australia 1,228,373 square kilometres. Indian reserves in Canada 28,000 square kilometres. Native community lands in Bolivia 16.8 million hectares. Indigenous territories in Brazil 1,105,258 square kilometers. Indigenous territories in Colombia 1,141,748 square kilometers. Indian reservations in the United States 56,200,000 acres.